case on this morning's docket. Case number 107324, State of Kansas v. Estrada Vital.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Francisco Estrada Vital. I request 3 minutes for rebuttal.
3 minutes is granted.
Your Honor, this is a direct appeal from drug conviction out of Finney County. Your Honor, I want to start by at least trying to frame the issue here that I think is on review, which is a very narrow issue of whether or not the issue that was raised in Mr. Estrada Vital's Court of Appeals brief was within the scope of the objection made at the trial court. The Court of Appeals did not rule on the merits of Mr. Estrada Vital's claim because they said it was not. So my understanding is we're not here to talk about the merits. We're only talking about whether or not the argument that was raised in the yellow brief is properly preserved and within the scope of the objection. And so that's where I'm starting here. So how do we figure that?
And if we agree with what I anticipate to be your position, that it was preserved, then the remedy is to remand to the Court of Appeals to consider the merits, or can we go ahead and consider the merits?
I think the general practice is if the Court of Appeals hasn't ruled on the merits, that you would remand to them. I know in civil cases you have, by rule, the power to sort of get to the issue. You're obviously the Supreme Court, so you can do a lot of things, I think. But I think that would generally be the remedy, that if you would say, you're right, maybe it's within the scope of this, but then it would be the Court of Appeals decision. So what was the objection? That's the Court of Appeals said that we raised a different issue than what was raised below. So what was raised below? I'm reading from Volume 5, pages 130 and 131. This is the trial, and this is the objection that was made at trial, which is obviously, this court has said, is actually the critical objection. It's, in fact, I guess the only objection that really preserves anything. And what was the objection? Counsel said, I would object the alleged cocaine was obtained as a result of an illegal search and seizure which violated Mr. Estrada's constitutional rights. Mr. Estrada was stopped on a traffic violation. The search of his person exceeded the scope of a traffic stop. There's a couple things about Miranda which aren't relevant here. And this drug evidence must be excluded as fruit of the poisonous tree. So this is the objection made at trial. And this is in conformity with the written objection, motion to suppress made by defense counsel. And this is Record 1, Volume 80 and 81. And I'm summarizing somewhat. But defense counsel argued that police seized evidence in violation of his rights and asserts the evidence must be suppressed as fruit of the poisonous tree. Police officers didn't have a search warrant, and noting that when police officers conduct a search or seizure without a warrant, it's per se unreasonable, and that the state bears the burden of proving then the lawfulness of all evidence seized. That's the objection that was made below. On appeal, we argued that officers illegally went into Mr. Estrada Vital's car, and in that car got a driver's license out of a wallet. And our argument on the merits there is that the officers didn't have legal basis to do that, and that as fruit of the poisonous tree of that discovery, they ended up arresting Mr. Estrada Vital partially, and then did a search incident to arrest, discovering drugs on his person. And so our claim on the merits was that the discovery of the cocaine on his person was fruit of the poisonous tree of the illegal search of the car.
How do we handle the colloquy between the court and the counsel where the court started to ask questions of counsel about what is it you were actually talking about? What is your objection? And that's Record Volume 4, pages 10 and 11. and the court said, anything in the vehicle that was seized that in the defense's position should not have been? Defense counsel answered no, Your Honor.
Sure. So there's a couple answers to that. And the first one, though, is that still goes to merits. I mean, that might be an answer on the. I'm not conceding anything here, obviously, today, but that might be an answer. The Court of Appeals might say on the merits that if defendant stipulated to that, affirmatively stipulated to that, then that's a fact that is contrary to my claim on the merits. I claimed on the merits that there was an illegal search of the car, and if the Court of Appeals would determine that's an affirmative stipulation of fact, then that would mean I'm wrong. That's happened.
Can it be a stipulation of fact? Isn't it also a legal conclusion?
It's a stipulation with regard to a finding on. It could be. I'm going to be clear. I'm never conceding anything in this case with regard to the merits because I don't think they're before the court. But
What the Court of Appeals really said, I think, isn't it, that the argument below was a challenge to the stop, but the argument on appeal was a challenge to the vehicle search. Isn't that really what they came down and says? You can't argue the stop. They weren't talking so much about the item, but the fact that reasonable suspicion to stop was the theory at trial, and unlawful search of the vehicle on appeal. Isn't that what they said?
that's a lot of what they said, and here's why I think that's wrong, Your Honor, is. And the comparison I would think of is let's think about for a second that the state has to prove some crime, and that crime has elements A, B, C, and D. It's just a hypothetical. And it certainly happens at times that trial counsel, for example, will really focus on element C for whatever reason at trial. That's what they're really focused on. And they lose on that because the case is on appeal. And now the appellate practitioner gets the case and may or may not agree with the argument about element C. But appellate counsel, when reviewing the record, says, oh, but it turns out there's insufficient evidence of element B. And you raise that on appeal. Why can that happen? Because the state has the burden to prove all the elements of the crime. And if they fail to do that, it's properly brought up on appeal. Similarly, by filing a motion as...
Stop for a moment. Say that again, that if you bring an issue one way before the district court, but the appellate counsel looks at it and argues something different on appeal, that's appropriate because the state has the burden? How does the district court ever decide initially on what's being brought on appeal? It never really addressed it.
If the state has the burden to prove, for example, elements A, B, C, and D, as they do in a crime or in a suppression case, then they're on notice that they have to prove all those things. And if they fail to prove all those things, then it's subject to reversal on appeal.
Even though it wasn't challenged in district court?
It is challenged in the district court, just like when a person pleads not guilty to a crime, all the elements are contested, right? And I don't have to affirmatively contest them. I don't have to do anything. Why? Because I don't have the burden when I'm the defendant. And can I raise, for example, the failure to prove element B on appeal, even though we never talked about element B at a trial maybe? I think the answer is yes. Why? Because the state has the burden to prove all the elements. Similarly here, when the defendant files a motion saying they have seized evidence without a warrant, what does that mean? That means all of the evidence obtained was presumptively unreasonable, and the state has the burden to prove the lawfulness of that at every point. And so this is the answer to your question, Justice Johnson, is yes, sometimes it will be more hotly contested about did they exceed the scope of a traffic stop. But does that mean that we have waived our right to contest on appeal maybe the stop itself? And I would argue that no.
Well, where I was headed is it seems to me that the basis for the Court of Appeals' refusal to consider the merits argument was that that particular argument wasn't preserved. And so where I was headed is I don't see in the record where the state ever objected on the basis of preservation. Did the state make such an objection?
In their blue brief?
Correct.
Yeah.
The allegation I saw in there is that the defendant failed to allege facts.
But the motion was insufficient.
And that's a whole different thing than the lawful argument or the legal argument. Because aren't we talking here about the Court of Appeals said the legal argument wasn't made below, and the brief of the state was the factual allegations were not made?
Yeah, I think that's right, Your Honor. And I'm just trying to remember, and I'll obviously look when I sit down, but my memory of the blue brief is that they argued, as they did in the district court, that the motion was insufficient, not that it wasn't preserved. Justice Luker, I want to come back because you asked me a two-part question. I don't think I've answered the second part yet. On this colloquy about, are you really talking about the evidence seized from the car? The other part of that, and I think it's ambiguous from the reading of that transcript, is the question, and I think the question for the prosecutor is, we're not using anything in the car in the case. So are you arguing that something from the car needs to be seized as evidence itself because we're not using any of it? And the answer to that was no, they're not using any of that in their case in chief. But our argument on appeal is that they used some part of that, what they found in the car, as information that led to
His arrest.
what we
Alleged
were
arrest.
claiming needed to be seized. Now, again, Your Honor, I'm not conceding anything, but reasonable people might say, on the merits, you're wrong. It's not fruit of the poisonous tree, and that's why you're wrong. But that's a merits decision. And so the only question is whether the argument that we raised in our brief is within the scope of the objections read here. And Your Honor, given the nature, particularly of suppression issues, which are that in a warrantless search case, the burden is on the state to prove the lawfulness, and they have to prove the lawfulness at every step. And what I really think the problem with the Court of Appeals decision is it says sort of, well, because you really argued about this part, therefore you must be, I guess, waiving or somehow abandoning, not even preserving any issues on other parts, right or wrong. And that's the real problem with the Court of Appeals decision. We might be right or wrong on the merits, but it seems to me the issue that we raised was that the evidence taken from his person was the fruit of the poisonous tree of an illegal search of the car, and that was one of the objections at trial.
But if one of the purposes of requiring a specific objection to whatever the issue is at trial is to give the district court a fair opportunity to rule, and if you put in play the Fourth Amendment and the trial judge says, well, what about it? And you say, oh, go look over here. And the judge says, okay, I looked over there, that's wrong. And then on appeal, you want to say, oh no, you should have looked over here. That doesn't give the trial judge a fair shot at trying to rule on your motion or correct an error if they have made one. Because you've misdirected the trial court.
Your Honor, I guess I would recharacterize it and say it's not an issue of the trial court. It's a matter of, does the state meet their burden? Just like in the example that I've given you with elements of a crime, right? You might make that same argument that, look, all you argued about was C, and somehow that's misdirecting a fact finder. No, we tell every fact finder in every case, you have to find all the elements, regardless of whether the parties have contested it. And why wouldn't that same rule be true when the statute and law says the state has the burden of proving the lawfulness of all the searches and seizures if I have my prima facie case? And the prima facie case is they did some search and seizure without a warrant. It's everything then is per se illegal unless they prove it.
So you're saying it's enough to just object and say Fourth Amendment?
I have to have
And then
some.
and then on appeal, you can take the record and create any issue you want as long as it relates back to the Fourth Amendment.
If I have like a prima facie case, I don't know if I could just say Fourth Amendment, but in this case, it was Fourth Amendment in that there was a warrantless search and seizure.
Well,
Therefore, it's per se unreasonable.
don't we have a statute, 2232-16 subsection 2 directs that the defendant's motion shall state facts showing wherein the search and seizure were unlawful. And so we can't just say Fourth Amendment. We have the motion has to set forth facts from which the trier of fact can determine if those facts are tantamount to a Fourth Amendment violation.
Yes.
What we're really arguing about is who has to make the legal argument. And if I understand you, you're saying once you set up the facts that a search occurred and there was no search warrant, our case law says that means we have a per se unreasonable search. And there's then exceptions to that, and you're saying the state has the burden to prove the exceptions rather than the defendant having the burden to negate any exception. That's really where we're at, isn't it?
That's right. And I don't think that's unfair. The state has the burden to prove this. And, there's a lot of exceptions in cases. But, Your Honor, Justice Spiles, especially if you would put a higher burden than that on defendants, it will be very onerous. You have to remember, we're not even guaranteed to have the police reports at a lot of these cases. A lot of times you do, but you're not guaranteed by statute to even have that information. The way you get that information a lot of times is by filing the motion. Thank you, Your Honor.
Any further questions? Thank you, counsel.
May it please the court, William Votipk on behalf of Finney County Attorney's Office. Based on the dialogue between appellant's counsel and the court, the state's position is that the Court of Appeals properly determined this case. What I think is important to note is that in our brief, we did note that on appeal the defendant we made the argument that Mr. Vitale attempts to clarify or allege his allegation for the basis of the motion for the first time in his brief. And consistent with State v. Johnson, on appeal, the defendant may not present reasons for suppression that were not presented to the district court. And I think
Counsel, what about the analogy to sufficiency? We don't require preservation for sufficiency.
I think there's a difference for sufficiency. If it's one element over the other, I think there's a distinction between a traffic stop and a search of a person, as was the case in this one.
There's obviously a factual distinction, but there's no distinction between who has the burden. Isn't counsel correct that once there's been an allegation that a search or a seizure is illegal, that the burden shifts to the state to demonstrate that it had an applicable exception?
And I would agree that that's true.
Okay, so that's not distinct. The burden has shifted to the state at that point, in the same way that the burden is always on the state to have sufficient evidence of all elements of the crime.
That's correct.
That's what I'm stuck on.
Okay. And I think that the issue regarding that is that all the issues that were presented before the district court, there was no allegation of illegality to the stop. The only allegation regarding unlawfulness as it relates to the search of the vehicle when they found the identification, and that was never addressed, brought up, or preserved for...
I understand what your point is, but why should the rule be different for this when the state has, when you've acknowledged that the state has the burden, than it is for sufficiency where the state had the burden?
Okay.
That's his point.
And I guess...
if the defense doesn't have any burden to come forward with evidence...
Correct.
Which it doesn't, right?
Yes.
Then how is this different?
Different in what way? I guess I'm...
Well, how is this different? Why should the rule be different? Why should we require specific preservation of particular arguments having to do with whether there was a Fourth Amendment violation by the defense when the defense has no burden to go forward in the trial court?
And I think that is maybe the issue that we're here to decide. I think in the circumstance or an instance where there's just a blanket allegation of a Fourth Amendment violation and without any other particularity or the opportunity, as Justice Biles was talking to, about giving the district court the opportunity to rule, then I think that it gets into, if they can waive the argument, then that would have occurred.
Waive what argument? Let's look at the search of the car.
Okay.
Okay, we have, I mean, I disagree with your brief that says the facts aren't alleged, because if you look at the motion, it talks about the wallet being retrieved from the center console, the driver's license check. It goes through exactly what happened, all the facts that they need to argue that the seizure of the wallet was not authorized. And then on their argument, they argue that they seized the evidence. It must be suppressed as fruit of the poisonous tree. They were talking about that search exceeded the scope of the lawful seizure. And 2232-16A says the motion shall state the facts showing wherein the search and seizure were unlawful. So once they state those facts from which the district court could make the ruling, then the burden of proving that the search and seizure were lawful shall be on the prosecution. So why isn't it your obligation to establish the exception that applies here?
I think that it is our obligation. I think I would agree we have the obligation to prove, but I think the argument that
So why does why would the defendant have to say this is unlawful because?
And I think the argument is whether or not they have made a complete or fully satisfied the requirement of the statute regarding the motion articulating a full basis or basis other than just Fourth Amendment. And if all they have to do is...
It doesn't say that. 3216-2 says the motion shall state facts showing wherein the search and seizure were unlawful. Then the burden for proving shall be on the prosecution. So once the facts are laid out from which the court can make a ruling, it's up to the state to say which exception applies. How's the defendant even going to know which exception to negate? In this particular case, that the state could have said the wallet was seized pursuant to consent. He consented to me getting in the car and getting it. It could have said there was probable cause and the exigent circumstances were provided by the mobility of the vehicle. They could have said he was arrested, so this is a search incident to arrest. So how is the defendant to know which argument to make until the state starts carrying its burden or carries its burden to produce evidence of lawfulness? You understand what I'm saying?
I do understand it. I think that you've clarified it, and based on that discussion, if they make the challenge to the search or state that it's illegal, and then the state has to come forward and provide the exception, then I would agree that that is the case. And in that instance, we have the opportunity and the obligation to carry the burden.
So you win the motion to suppress. We move on to trial. Then what is the obligation of the defense at trial?
Obligation at trial is then to preserve the issue for appeal by objecting contemporaneously.
And specifically, or what do they get to say at that point? How broad can that be?
Well, I think that has to be contemporaneous and specific enough to give the trial court notice and to have a fair opportunity to make a determination, because what that does is it gives the courts the opportunity to reduce the possibility of reversible error based on the ruling at the district court level. So I think that it has to be contemporaneous and specific enough to fully preserve what the objection or challenge to the admission of the evidence is.
And is anything that happened at the motion to suppress binding on either the defendant or the state at that point?
It is not. It would be an opportunity to either renew. I think it's binding from the standpoint that it's a prior ruling, but it's an opportunity for it's a necessity for the defendant to object to preserve that issue for appeal.
So are you saying that at trial, even though the motion, statutorily, the motion just needs to state facts, you're saying that when you renew that objection at trial, then the defendant has the additional obligation of setting forth the illegality and the prosecution no longer has the burden to show lawfulness?
I think that what needs to be done is not necessarily show the illegality, but at least object or preserve that issue for appeal.
Okay, the objection here was, Your Honor, I would object. The alleged cocaine was obtained as a result of an illegal search and seizure which violated Mr. Estrada's constitutional rights. Mr. Estrada was stopped on a traffic violation. The search of his person exceeded the scope of the traffic stop, and then it goes on to talk about Miranda's, and then it says, and this drug evidence must be excluded as a fruit of the poisonous tree. What part of that didn't put the trial court on notice that there were facts alleged showing an unlawful search and seizure?
Justice Johnson, I think that it does sufficiently and say that there was a Fourth Amendment issue or challenge.
Can you help me here? I don't recall. Didn't the Court of Appeals find that the objection at trial was sufficient to preserve the objection? It was just a theory of unlawfulness that was not preserved? We can go back and look at that. I don't want to throw you off. Yeah.
No.
My understanding is after that objection, the court just simply overruled.
Correct.
Yeah, there was no discussion. The state didn't come forward and make a proffer as to why the search was lawful or anything. It was just that already been done, so the court said overruled. Is
Correct,
that
Judge.
accurate?
So,
Basically, didn't the court incorporate the prior ruling? It's some,
If I recall,
basically
it
say
did.
something about it being based on its prior ruling or something.
I believe so, yes.
so in this case, we have the motion to suppress, the hearing, the denial, a objection at trial that you agree would preserve that question. What else? What needs to happen here for the Court of Appeals or for us to reach the question in terms of preservation?
I think our argument is or was that based on the specific objection or allegations under the Fourth Amendment that it wasn't properly preserved for appeal. If the brush, as discussed with Justice Johnson, if that broad brush stroke of the Fourth Amendment or the allegation, the state's failure to present or carry the burden why or what exceptions apply, then it would appear that this would be something that would have to be examined, or whether or not there was a lawful basis to grant the motion to suppress.
Well, do I hear you saying that you agree with counsel that we're down to the real crux of the matter is whether the defendant has to specify which exceptions are not applicable or were violated versus the state having to prove the existence or specify and prove the existence of a exception.
Well, I think what has to be shown is they have to make the objection to the Fourth Amendment, and they've got to specify facts. And the facts that were articulated in this case were that the violation of the Fourth Amendment was based on or predicated on exceeding the scope of the traffic stop. And I think based on the concessions made by parties at the pretrial hearing and the fact that the issue wasn't addressed regarding accessing the wallet or finding the identification.
Counsel, are those, if I can just cut to the point.
Sure.
It sounds to me like you're arguing that at the hearing, defense counsel essentially conceded that the arrest was lawful. Did that happen?
She conceded that there was a lawful basis for the stop and then argued that the subsequent search exceeded the scope of the traffic stop.
And I'm looking at the transcript and the court asks, did they have a reason to arrest him? And defense counsel says they did.
They did. And so she would have conceded there's a reason to arrest him, and as a result it would have been a lawful search.
So does after that colloquy occurs, does the state still bear the burden to show that a search incident to that arrest should not be suppressed as fruit of the poisonous tree? I mean, once defense counsels said they had reason to arrest him.
Well, after the concession or even the stipulation or agreement on those facts, I think that would be sufficient as a basis for determination of the suppression.
But the question, I don't want to sound like a broken record, but I'm going back, does the defendant, once that all comes out, have to tell the court, the search incident to arrest exception does not apply because 1, 2, 3, or does the state have to say, we are relying on the search incident to arrest and here's why it applies?
I think it's the state's burden to go forward, prove and produce, or present that argument, carry the burden. The defendant does not have any burden other than to make the initial attack under the Fourth Amendment to suppress.
In this case, did the state in the trial court carry its burden to show which exception applied to the grabbing of the wallet out and the search of the wallet from the car? Because I think, quite frankly, I don't know to this day what exception the state's relying on. You're just relying on, well, they didn't argue that correctly or didn't say why it was unlawful. But I don't see anything in the record where the state ever said why it was lawful, which exception it was relying on.
And I could look through the transcript and see, I think, and I think more of it was based on, as Justice Stigall said, based on the stipulation or the admission, the agreement, or the concession that the stop was legal, the subsequent arrest was legal, and thereby the inference or it was reasonable that if in fact the stop was reasonable or legal and the arrest was reasonable or legal, then it would be a search incident to arrest. And
why would that be legal? If the person was removed from the car and it was no longer within the immediate presence of the person, don't we have case law right now that says you just can't go in and dig around in the car?
I understand, but based on the fact that at the time the car was pulled over, it was pulled over for registration violation, which was a misdemeanor, and so under the objective...
Well, counsel, I may have this wrong, but the evidence that the defendant seeks to suppress is the drug evidence, correct?
Correct.
And that evidence was found on the defendant's person, correct?
That's correct, Your Honor.
After the defendant was arrested,
Yes.
correct?
Yes.
Okay.
But the arrest was made after they seized the wallet, got the information that he didn't have a license or whatever. The arrest was made based on information that was obtained from the wallet to run through dispatch.
The arrest based on the his license being revoked was based on that. But I think and instead of it being based on the subjective knowledge of the officers, but if you apply the objectively reasonable law enforcement officer and whether he would have had probable cause to arrest him under the registration violation, then based on that analysis, he would have had an opportunity to search him, incident to arrest, and the drugs would have then been found. No,
Counsel, did the defendant ever in this process put the state on notice that they were challenging the discovery of the wallet as a Fourth Amendment violation?
there was nothing in the motion to suppress that challenged the discovery of the wallet under the Fourth Amendment.
And at the trial, the contemporaneous objection also does not challenge the search that resulted in the discovery of the wallet.
That's correct.
Okay.
What did the defendant mean in his motion when he said, quote, all evidence obtained as a result of the unlawful and unreasonable search of the defendant's vehicle, end quote. And then he goes on to say the wallet was retrieved from the center console area and the wallet had identification that identified the defendant, and then goes on to give the rest of the scenario.
Where is that, Justice Johnson? In the motion to suppress?
He filed a motion to suppress, and that's Record Volume 1, page 81, Volume 4, page 3. That's what I have in my notes. The quote is, he filed the motion to suppress all evidence obtained as a result of the unlawful and unreasonable search of the vehicle. If that is in fact accurate, why wouldn't that be putting the state on notice that the stuff that came out of the vehicle was being challenged? If that's correct. And we can verify that from
Sure.
the record.
And I do have the wherefore on that, Judge. You're exactly right. The wherefore does say evidence obtained as a result of the unlawful and unreasonable search. I was looking up in the arguments portion. Well, there was no evidence that was seized from, or no evidence sought to be suppressed. I think they wanted to suppress the cocaine evidence.
And counsel, I
As
think
fruit
this
of the
is
poisonous tree of the other seizure. That's where we're having a disconnect here.
I know, and I understand, and we argued in our brief that identification in the body of a person is not suppressible as a fruit of an unlawful arrest, even if it is conceded that the unlawful arrest, search, or interrogation occurred. And so by virtue, and I think we're probably digressing into the merits more than what we needed to, but I think that when you analyze based on Warren or Schmitter, it's distinguishable from the standpoint that in those cases there were drugs or other evidence. It wasn't the identification that was found or an issue that was suppressed. It was actually the drug evidence that they used searching for identification as the basis to find that drug evidence. In this incident, I think they weren't searching necessarily for drugs. They found the ID, found out who Mr. Estrada Vital was, and after they found out who he was, because he didn't previously identify himself, they ran the check through and found at that point that his license was revoked and took him into custody. But even applying the objectively reasonable officer and the facts he had known to him based on the registration violation, they had the opportunity, or would have had the opportunity, to search him upon arrest for that.
But
I
they
think
did.
everybody understands that. Just so I'm clear, he was arrested for driving on a suspended license.
Correct.
Okay. He wasn't arrested for the registration problem.
not what had happened is after they found out he was suspended, they were arresting him.
Stopped
Yes.
him for the registration, found the wallet, knew who he was, arrested him on suspended, searched him, incident to that arrest, and found the cocaine.
That's correct.
Thank you.
Any more questions? We've kind of peppered you with questions. Would you like 30 seconds to wrap up, or you think you've made your points?
We would just stand on the position that the Court of Appeals got it right. We just ask that you affirm their decision. Thank you for the opportunity to be here today.
Thank you. You reserve three minutes.
I don't have anything else unless the court...
I have a question.
And I do as well. Go ahead.
Counsel, was there a contemporaneous objection to the testimony about retrieving the wallet and opening the wallet, obtaining the wallet, and looking at the ID
At trial?
at trial?
No, I don't think there was at that time. I think the objection came at the time when the cocaine itself, the evidence that they wanted suppressed in that regard, was being introduced at trial.
So is that too late when it's, the link is that wallet and the ID?
Your Honor, I mean, I don't think you relitigate the suppression issue before the jury. And so, no. Again, the issue here, the claim that we're making on appeal is that the admission of the cocaine was unlawful, that the seizure of the cocaine was unlawful. Now, it's based on some predicate facts like those, but I don't think that we were claiming that, you know, that discovery of that wallet was, that we didn't object to that at trial, because we're not saying that that's the part that we're objecting to, even the admission of that at trial. We're objecting to the admission of the cocaine. The Fourth Amendment claim is that discovery of that cocaine as a search incident to arrest was fruits and instrumentalities in part of that seizure,
But
not that it independently was illegal.
More fundamentally, counsel, there was no complaint about 6404 being violated in the Court of Appeals by the state, was there? And the Court of Appeals found that the objection was sufficient to preserve the challenge.
Well, I'm not sure the Court of Appeals did. I mean, they said we changed our theory, and
Right.
by doing that,
Right.
are arguing things that are not preserved on appeal. And so I really think that's the narrow issue here. And I think that's an important distinction, and it kind of goes to one of the questions you had earlier, Justice Rosen. I mean, you talk about the specificity requirement from 6404, but that's when we're objecting to evidence on hearsay grounds or whatever. And in those cases, we have the burden. When I object to evidence, I have a burden, and it's appropriate then to say you have to be that specific. But that's the difference here. And it goes to the idea, Justice Biles, in this kind of case, that we're dealing with sort of the broadest situation where if the state obtains evidence without a warrant, everything is presumptively unreasonable. And we should hold the prosecutor to that understanding, and that they are going to come in on notice that they better prove everything was lawful.
Counsel, on that subject, that's a good segue to my question, which is, it strikes me that what we're struggling with here is that defense counsel really didn't connect the dots of its fruit of the poisonous tree argument, because it filed a motion that did sort of prophylactically object to all the evidence, including the evidence that was found in the vehicle. However, at the hearing, the court asks defense counsel specifically, is there something in your motion to suppress? And then he says, anything in the vehicle that was seized that in the defense's position should not have been. And defense counsel's answer is no, Your Honor. I mean, why doesn't that take that issue off the table? The issue of the seizure of the wallet, which is the key question in your connecting your dots in your fruit of the poisonous tree argument.
So the two responses are, first of all, maybe that is an answer, but that's still an answer on the merits. And that's the point. Is
Isn't
we
it a
didn't get to the
preservation
merits.
question, though? Because as I read the transcript, defense counsel is saying, we're not going to put the state to its burden on that. We're not challenging that. We have no objection. We're not even making the prima facie claim that the seizure of the wallet violated the Fourth Amendment.
And then you have the more apt answer is, again, defense is arguing again, not that because they're not going to put any evidence of the wallet in their case in chief
I
necessarily.
understand that, but the court gave the defense counsel an opportunity, just teed it right up there to make the fruit of the poisonous tree argument. Says, is there anything that was seized from the vehicle that should not have been? No. I wonder what, and it goes back to Justice Biles's question, how is the court, the district court, supposed to proceed after that? He's given defense every opportunity to make their argument, and they've not made it.
The district court didn't say, and based on that, you agree then everything else was lawful, right? And that concession was never made.
But the defense counsel was technically right, because they weren't objecting to the wallet. They were objecting to the information obtained out of the wallet, so they weren't trying to suppress the wallet or anything in there. It was just the information. Because then the trial judge says, is there anything out of the car that you're trying to suppress, or something to that effect? And it was the information that was unlawfully obtained, but not suppress the wallet.
The point that I'm not very successful in making is the idea that a lot of these have to do with the merits. And the idea here is whether it's within the argument that we've raised on the idea that we know that a lot of times, especially in warrantless Fourth Amendment cases, there's a lot of steps where the state can, if you don't prove it's lawful, it's going to be deemed unlawful. And that's right. That's the way we should handle cases. And prosecutors and district courts should be and are on notice of that.
The problem I've got, one of the many problems I have, but I'm kind of scared when I think about the application of the rule that you're searching for, because on appeal we rely, and we have a two-step process, are the facts as determined by the district court, supported by substantial competent evidence, and then we go and apply the law. And if defense counsel at trial has said, Judge, look over here as to why we're supposed to analyze, how you're supposed to analyze a Fourth Amendment problem, and then you get up on appeal and say, oh no, look over here, how do we have substantial competent evidence to support the facts that you need to make your new argument? And I don't think the answer here is that, well, they stipulated there. I mean, that's not the answer, because I'm looking at the application of your rule in the future. And I just think we're going to end, I think that's the reason why you have these restrictions on preservation, so that we know we've got the issue teed up properly.
Your Honor, I don't think it's the concern you have, because we should have the prosecution and the district court know that when there's a warrantless search like this, that counsel may focus on one part of it, but the state still has to prove their whole case. Think about the converse. This is the real problem, Your Honor. The converse of if you don't adopt my rule and you say, even though the state has the burden of proving this, we're really only going to consider issues on appeal that the defendant has affirmatively disproved. Well, why even have the statute at that point?
All we have to do is, all defense counsel has to do is to know enough to point the court in the right direction.
The statute should point...
And then those arguments can be analyzed.
The statute should point the court in the right direction. Prove that it's lawful.
Any further presentation?
No, Your Honor.
Any more questions? Thank you, counsel. Thank both of you for your arguments this morning. The court will take this matter under advisement. This time